the new restrictions come in today, and they say that children are allowed to travel between homes of separated parents. So that's great news. It's very clear about that. What it also says is you're allowed to travel if you are complying with a court order. So anyone with a child arrangements order, that's very express. You must abide by your order. If you don't have a child arrangements order, you just have agreement, or even if you don't have like a formal agreement, it's just, we usually do this, carry it on, you're allowed to do it. It doesn't have to be in a court order. The other thing to be mindful of is if you're in a contact centre. Usually if you're in a contact centre, it's probably in a court order anyway, so we know that you're allowed to comply with a court order. Contact centres, as far as I can see, as I was looking very late last night, they are open, but I think it will come down to each individual contact centre. Of course, if their staff are off sick, then they can't open. But yeah, if your contact centre is open, then as far as I'm aware, as long as you're abiding by the social distancing, they're able to still facilitate supervised or supported contact. The National Contact Centre, I think it's committee, their website, if you Google it, they've got precedent letters that you can download, which if you were to be stopped on your way travelling to or from a contact centre, it will give you a precedent letter that you can download and show evidence of what your purpose is for travelling. I think that's quite extreme, and I think it's unlikely that the police are going to be really stopping everybody at this point, but it's just good to know that you can get it if you're unsure. As far as things like what happens if anyone gets symptoms, people really are panicking, and that's something that came up a lot in the previous lockdown. Well, someone, it may not be the child, it may not be the parent, but it might be someone in the household. They've got a high temperature, or they've suddenly developed a cough, and you don't know yet if it is COVID or not. The default position is you must, the laws are very clear, you must stay at home. So if someone in your household and if someone in your bubble has symptoms, or if you're told by track and trace, you must self-isolate, that is your overriding, you must do that.
So if that happens and say it's you that gets it and your child is with you at the time and supposed to be going to their other parent like 2 days later, what is the child just self-isolating with you during that time?
I'm sorry, my internet's going a bit slow.
No worries. I said, so if you're the person who tests positive or who's been told to self-isolate, does that mean that if your child is with you and they're supposed to be going to the other parent in a couple of days, that they stay with you to self-isolate?
Yes, so the isolation rules apply to the household. So if someone in that household has symptoms, the whole household must comply with those isolation rules. So if the child is in that household, then no, you can't facilitate it. It is slightly conflicting because the rules say you're allowed to travel, but the default is if you've got symptoms or someone in the household has got symptoms, you must self-isolate, because the whole purpose of this is to stop the spread of the virus. So yeah, transporting the child between households at that point is potentially spreading the virus. So yeah, no, the child should then stay, but you must be reasonable, and that's where you then should think about offering safe alternatives, video contact. So you say, look, they can't come, we've got to isolate for however many days it is, and there's different rules, aren't there? I think it's 7 days if you're the one with symptoms or from when you get the positive result, or 14 days if you're not with symptoms but someone in your household is. So you'll have to abide by those rules, but you can say, look, let's do a video call and whatever is reasonable or appropriate. You know, children this time are still able to go to school, they're still able to go to nursery. Your childminder is still allowed to come around, obviously subject to if you've got symptoms, but it is slightly different this time around.
And what if though it's, you know, because as a single parent and not having the backup of another adult to support in the house if you get sick, so what if, you know, you react really badly to the symptoms and you're actually quite ill, and then you're dealing with a you know, a baby and feeling like you can't care for them properly. I think
Yeah.
a worry for a lot of single parents.
I think that's a huge worry. I think at that point, it just comes down to your relationship with the other parent. You know, can you ask them for help, and would they be willing to help? You know, they may say, no, I'm not willing to help, because if I then get the virus, I can't work. I then can't provide the money to provide you with the, you know, maintenance or whatever it is. So I think it just comes down to what is reasonable in your specific family circumstances. What help could you call upon? Is that fair to call upon it?
Yeah.
And can you work through it together?
Yeah.
It is really difficult. I think it's probably right in that circumstance, if you're looking for help with the care of your child, to look to the other parent before you look to other relatives. So I think that's probably right. But a lot of this is you apply the rules, but then you also have to apply common sense, but specific to your family circumstances, because no two families are the same and relationships are all different. And so there is no kind of formula to what you should do. It's just a matter of, am I being reasonable?
Yeah.
And that's a difficult thing to ask yourself when, you know, a lot of situations, there's a whole background of stress and poor communication and frayed tensions and all of that. So it is really difficult.
Yeah, exactly. And then just the unknown of what's going to happen. Are the kids going to be sent home from school one day? Is it going to impact work? Is it going to impact the co-parent, you know, but.
And I think it's going to be harder this time because we're doing it in winter and the kids are constantly coming down with colds. And this time they're in schools and they're in nurseries.
Yeah.
I know from having a toddler myself, I've got a child at preschool, she's come down with 3 temperatures and we have to all go into isolation. And I think it's going to be much higher frequency that people are showing some of those symptoms, the cough or the temperature probably most common, that probably isn't COVID, but you have to abide by the rules. So I think this time round, we're going to have a much higher frequency of people saying, we're showing symptoms, we have to get a test. Of course, if you get your test and it's negative, then you no longer have to isolate. Yeah. So you can go back to your routine and order.
Yeah. Alrighty. Okay. Well, we can maybe come back to some more questions for anyone who's on the call who wants to get some clarity on the new lockdown restrictions or anything else. But we've been sent a ton of questions, pre-asked questions from people in the community. So we might crack on with those and leave some space at the end then for questions from anyone on the call, if that's okay.
Yeah.
Great. So the first one is, related to the coronavirus restrictions. So my ex is constantly breaking COVID guidelines and I'm concerned because my eldest has asthma. My ex has people visiting the house all the time and the man she left for comes and goes too. We're at a point in our divorce where I could tell her that 1 + 1 = 2 and she would argue with me. So talking to her isn't really an option. What are my legal options when it comes to this irresponsible parenting?
That's a question that's come up quite a lot actually in the last lockdown, people saying, I know they're breaching the rules, what do I do? And it comes down to what evidence you've got, because say you did take this to court and you're saying to a judge, I believe that they're breaching the rules. Of course, they're likely to say, no, I'm not. And it will be a judge to have to determine, who do I believe more? So the options are, if communication between you is not working, then you've got to switch it up. Try a different method of communication. Try putting it in a well-considered, well-explained email. If email doesn't work, maybe you've got a mutually respected intermediary that you could ask to try and mediate informally for you. If that isn't an option or it doesn't work, try a more formal mediator, an actual family professional mediator. They can do mediation via Zoom and everything, so it's still something that's available. If mediation isn't an option or they're not willing, then solicitors could write a letter. Last resort really is court. But if it's necessary, because you really are sure that they are posing a risk, they're not prioritizing the children's welfare, then it comes down to their parenting capability. And if you really do think they are not making the right choices and they're putting the children at risk, then you could make an application to court. And it's not just a matter of saying, during this situation, I want to change the child arrangements. It may go further and say, look, I don't think they are able to properly put the child first, and therefore you want to vary the arrangements, not just during COVID, but more long term. So the ramifications can be quite hard hitting, but it's difficult if you haven't got the evidence. It's just your word against theirs. You've got to think about what do I have to explain why I think what I think. It's not to say you've got to go kind of searching on the internet for evidence that they're breaching the rules, but if you do have something, then it comes down to that. But be reasonable, try and be fair, be child focused, all the usuals apply. But court would be a route if any of the optional but more amicable non-court routes don't work.
Okay. I wonder, are the courts busier? Well, obviously it's more restrictive, but is there a lot that you know of that's going into the courts about related to coronavirus and kind of issues with kind of parents and the other parents being irresponsible?
Yeah, so the courts are dealing with things. If you have an urgent application, the courts will deal with it. So I had one where it was about travel. Should a child be allowed to travel internationally? And now at the time it was where we weren't quite where we had come out of the big restrictive lockdown. But so now obviously that issue wouldn't come up. But the courts were able to very quickly deal with that and decide in those situations whether, bearing in mind the COVID rules of this country, the other country, the risk. So the courts are dealing with it. The courts are busy though. But they're better prepared this time, because the first time round, suddenly we were all launched into sudden lockdown and we had to react. Whereas this time, now we've got the systems in place, they're able to do remote hearings, the staff are set up to work from home. So it is better, but we are still running on backlogs. They are inundated. It is difficult, but they're open, they're doing their best. And I would say it's working. It's not ideal, but it's working. So I wouldn't be put off course because of the situation.
Okay, well, that's good to know. Yeah, I think we're all slightly more equipped this time round after the practice run a few months ago. Okay, what are the guidelines around COVID and an ex just starting to have contact? So I'm assuming the same.
So it carries on. Yeah. If it's like a supervised contact, remember that one person from another household is able to meet with one. You're allowed to do childcare and things like that. So I think that would all still be able to apply. It's just a matter of, being sensible, making sure you're wearing a mask, doing what you can to abide by the rules, but knowing that child arrangements are allowed to keep going ahead.
Okay, great. Thank you. Okay, next question is around custody and arrangements or arrangement orders. So my ex-wife and I have a 50-50 co-parenting order. My daughter at age 13 chose to live entirely with her mom, which is a major course of sadness for me. My other child, my son, who's recently turned 13, is less likely to contemplate, is less likely to complicate that. But is there a simple legal redress to prevent the same thing from happening with him?
So in that case, did they say they've got an order already in place, the 50-50? Was that an order?
50-50 co-parenting order.
Yeah. So a 13-year-old, their opinion would be taken into consideration, but it does raise red flags. Why at 13 is a child going from saying 50-50 order is in place to suddenly I don't want to live with the other parent at all. So that for me, I wouldn't just sit back and accept it because a 13-year-old has decided it. I would want to look further into why that 13-year-old has just decided that, what can be done to help that 13-year-old, because there is a presumption in law that it is best for a child to have a relationship with both parents. So to suddenly go from 50-50 to don't want to spend any time, that's really quite alarming. So I wouldn't just accept that. To the extent that they've already got a court order in place and they're looking at wanting to vary it, then you can vary a court order by agreement between you, but you've got to agree. If you don't agree, then you have to go back to court for a court to review the application, to review the circumstances, to review what has changed, to then make a decision on whether or not it is appropriate to vary the order and in what way. So for that person, I think they need legal advice. Just accepting that a 13-year-old doesn't want to do it doesn't mean that that is the answer. 13 is still quite young. Yes, they have a voice. Yes, they can shout and tell you what they want, but it doesn't mean it's right in their best interest. The parents are the ones who can decide that.
Okay, great. Next question. My ex-wife is an American citizen. What sort of age for each child am I protected from the possibility of the kids being taken from England to the States by their mother? She frequently talks about them having the real option of them both going to university in the States.
Okay. Well, while the children are minors, there isn't like an age where there is a safety net. You know, child's relocation is a parental responsibility decision. So whatever the age of the child, if you want to relocate your child within the country that you're currently in, but a significant distance, or to another country, you must agree, both parents must agree. If you don't agree, then you'll need to make an application to court. And the court will assess it on the basis of what's in the child's best interests. And that has to be weighed in the balance of what are the benefits of that child moving against the disadvantage that will have to the relationship with the left behind parent. So it's not because they are under 10, you're fine, they won't be allowed to move. They could still be allowed to move. It's the welfare test that the court would need to look at. The reference was to the children going to university in a foreign country. At that age, the children would be much better placed to make decisions for themselves. So university age, I think, would be different.
Yeah, that makes sense. Okay, next question. My ex is taking me to court again to try and vary the current, the CAO, so that's contact arrangement order.
Child arrangements order.
Child arrangement order. I have to represent myself in court. My ex has lied in his C-100 application and I have evidence to prove this. Is there any way to present this evidence to the court prior to the first hearing on the 15th of December?
This is a really common thing that comes up. Someone makes an application to court and the other parent says, that's a lie, that's not true, they're lying in their application to court. What you've got to understand is it is one person's opinion. This is their version of what they think is going on. The fact that you have an opposing opinion, perhaps with evidence to suggest that their opinion is wrong, is part and parcel of the court proceedings. It is what the court will take into account as part of their overall consideration. Getting it in before the hearing won't really make any difference because the court won't review it before the hearing. That's the purpose of the hearing. What will happen before the hearing is CAFCAS, that automatically allocated every time a new child arrangements application is made to court. CAFCAS are informed. They will call both parents before that hearing. It's supposed to be about 7 days before. Sometimes it can be, a couple of days or the day before. But they will call you and they will ask you, what's happening in this situation? Why is the application being made? What's your opinion on the circumstances or the case? So you will at that point get an opportunity to put your case forward. And CAFCAS will do a background check and they'll do a safeguarding letter to the court. And it will be a summary of the conversations they've had with both parents, and they'll also do police records, local authority record checks, and it will flag up anything that comes on those. That's the only way you can really, before court, put anything before it. But really, it's a matter of going to court, saying why you don't agree, the court will then give you an opportunity to put your own evidence. It's usually a narrative statement. So that first court hearing, the judge will say, I want to have statements from both parents. And there is your opportunity to put your evidence first.
Okay, that's really helpful. So the next question, there is a contact arrangement order, child arrangement order, where the contact part states, the children have contact with their father for the entire October half term. However, the every other weekend is only in the recitals part of the order. Is this a choice for the children, or is it part of their contact order?
That's a difficult one. I'd need to read the order. Every order is different. They're all written bespokely. So I'd need to read the order in that case. So I can't really comment on the specifics. But what I would say is there is a difference between what is in the child's best interests in the parent's view and what the children think is what they want. And if your children are not kind of, the older they are, the more weight is given to their opinion. But just because they have an opinion on it doesn't mean that that outweighs the parent's opinion. If the parents don't agree, then you need to utilize other methods of trying to reach agreement. This is where mediation comes in. Arbitration is useful. If you still can't reach agreement, that's where you should then ask the court. And the court can take into account the children's wishes and feelings. So it's really about, looking at it holistically, not just saying the children have said they don't want to come this weekend, so that's it. It doesn't work like that.
Yeah. Okay. The next one, my daughter lives with me full time. Contact has always been at mine or with me in the vicinity, as she openly states she doesn't trust him, the other parent, and doesn't want to be left alone with him. He's very manipulative and a bully. We've tried loads of mediation, but I ended up giving up as the mediator wasn't stopping him from bullying me and actually made him worse. If it goes to court, what can I do to maintain contact, but on her terms and not overnight? She's 8 years old.
So again, 8 years old is very young for a child's opinion to be determinative. The parent herself has got concerns about him. She's made reference to perhaps some allegations of perhaps abusive behavior. What she would need to do if she goes to court is to really explain her concerns, the concerns that the child has informed her, and the courts would then need to do a proper investigation. That's where CAFCAS come in. CAFCAS can look into it further. But 8 is still very young. So again, that yes, they have an opinion and their voice needs to be heard, but there's only so much weight that can be given to such a young child's opinion. Hiding behind a child saying, I think this, or I don't want to do this, is difficult position to hold. You as a parent are also expected to encourage contact. So if a child is saying, I don't want this, it's not enough to simply say, because the child says it, it's not happening. You need to look into, why is the child saying this? What can be done? And if the other parent isn't receptive or isn't willing to engage in looking at why that behavior is happening, then that's what you need to ask the court to look into and the court to assist you with.
Okay. The next question asks, currently waiting to hear from my solicitor. I'm in the process of changing my name, and due to a domestic abuse case, my ex is not allowed near me. I have an injunction against him from the courts. How long should I have to wait to hear from my solicitor, and how likely is it that the case will go in favour?
I can't really comment on the chances of success. I don't know the case, the details. It's also specific in family law. No two families are the same. No two circumstances or events are the same. So I can't comment on that side of things. But as far as working with your solicitor, if you think, I'm still waiting to hear back, send them a little chaser. We are all busy, but at the same time, we're all human, and it may be that they've just overlooked something. So just send them a little chaser. Don't feel like you're just having to wait and be told. Just drop them an email, give them a ring.
Okay, great. So now we're going on to some financial questions. The first one, can your ex claim half of the house if they don't pay the mortgage?
It depends if they're married or unmarried. The law applies very differently between spouses, so married couples that are separating, and those who are unmarried, cohabitees who are separating. If you're married, the financial contributions argument matters less. The court have not rigid formula, but kind of guidance about what circumstances are taken into account when looking at how to distribute the financial assets on separation. In cohabitees, so people who are unmarried, it's far more rigid. The law comes down to land law, really, who owns what. And if you don't legally own it, can you evidence that you have put in a financial contribution to that property? And if so, then what is your share as a consequence of that financial contribution? So the law applies very differently, but just the absence of paying the mortgage, if it's a marriage situation, doesn't prevent you from getting a share on the property.
Okay. Next question. I'm in the last 6 weeks of completing my divorce and have had no request from my ex-partner for any money or other wishes. If she doesn't ask for anything in the next 6 weeks, are my home savings and pensions safe?
No. No, they're not. The divorce and the finances, although are intermingled, and quite clearly intermingled, practically, in law, the application for the divorce is purely the end of the marriage. It is dissolving the marriage certificate to a decree absolute and finalizing that. Although on the divorce petition, it asks questions about whether or not you seek a financial order, it actually doesn't prevent a later claim to deal with your finances. The finances is separate. So the fact that they haven't addressed it does not mean he is safe and what is his. What it means is he will always be looking over his shoulder, because at any point his ex-wife could come back and say, actually, we didn't resolve our finances, we now need to do it. So I would say be proactive in that circumstance. Don't try and bury your head. Really look to resolving that and getting it. Even if you agree that you each keep your own, you still need an order to say that you each keep your own, and you dismiss each other's claims against each other. Otherwise, they remain open. The only thing that I would say is remarriage would affect it. So if his ex-wife then went on to remarry, then to some extent, without wanting to go into loads of detail, to some extent her claims would be limited by that remarriage.
I was just thinking, I just had an idea for another meetup. I feel like maybe we should do a session on what you would advise to people in the Frolo community before they go into their next relationships, about steps we can all take to protect ourselves financially and otherwise.
It's amazing, actually, that people can come out of a really terrible separation and go into a new one because it's lovely and we're happy and thank God I'm happy again. People can lose sight and not think, but what do I need to do to protect myself? And often people think, well, it's fine, I just won't marry again. But there's still things that you need to do to protect yourself, even if you choose not to remarry. So I think that's a great idea.
Okay, well, we will definitely do that. I think it would be so helpful. We all need to learn from experience. So the next one is, what of the following is the best to do? Apply to courts for a force of sale of the marital property, or apply to courts to ask for support with moving back into the property, or getting my ex to move out. I had to move out of the family home over a year ago due to safety concerns and a difficult home environment. It's a joint mortgage and my ex has been living in the property and refuses to support our child financially and move out or sell. I've been living in a rental and pay more for the rental than the mortgage. I want to be in a situation where I'm paying less for the rent, or I'm able to buy a property to reduce my monthly outgoings. Unfortunately, I'm unable to go anywhere due to having my name on the marital property mortgage. I'm looking to force a sale, but I don't want to waste money going to court if it is going to lead to any more of my ex of my ex not co-parenting, wasting money on mediation, etc., is only going to set us back?
That's a difficult one, and one where I think I would need more information about the detail of what's gone on, what their financial position is, and then to say, well, this is a good route for you. The options that have been suggested there, getting an order to return to the property. Well, you don't need an order to allow you to return, but the suggestion being that she was kind of moving for her safety, then perhaps she doesn't want to return while he remains there. So in that situation, it would be an occupation order. An occupation order is where you apply to the court for an order that one person is out and the other person is in. And it could be in the whole property, it could be just in part of the property. It can also go as far as saying who pays for what. But it's quite draconian order, to have someone removed from their own home. So the threshold is quite high to get one of those.
Okay.
But domestic abuse is one of the main reasons for getting one of those. To get an order for sale of a property, the courts don't have the power really to order a sale of the property unless you agree, or at a final hearing, and a final hearing can take a while to get there. It is a long haul, but it's a necessary means to an end if you can't reach agreement, and that's very difficult circumstances. If it's weighing up the benefit of my only way to get the help I need and the access to my money is going to court, but I have to spend money to get there.
Yeah.
Query whether legal aid might be available. It tends to be available still only in cases where there's domestic abuse or has been domestic abuse. So check that first. But otherwise, it may just be a necessary means to an end.
Okay.
And there are funding options available. So, just if you don't have the money in your bank account, doesn't mean you shouldn't pursue it. There are other options.
Okay, great. So the next one, I'm a stay-at-home mom with nearly 3-year-old twins, one of which has autism. I've got to start thinking about the finances. I have a mortgaged house with my husband. Myself and the children are living there. I'm worried about the division of the property. I have no income, so can't get a mortgage. Even if it's a bigger share in my favor, I still cannot buy anything. My husband is in a very well-paid job and has bought another property with a member of his family since we split. I was wondering what my options were.
That person needs a detailed meeting with a family lawyer, because an initial meeting with me would probably take about an hour and a half, and in that meeting I would go through the more detail of what actually she knows of their finances, and then to talk through what all the options are. There are a variety of options, and she shouldn't fear going through that, because she would be protected. They've got young children, there is money there, it sounds like, so she would be fine. It's just a matter of her getting bespoke advice to their circumstances. And again, it costs money to get the advice, but I think she would be so reassured having got that advice. Okay. Other option, of course, is to read my book. I put in there my book about how the courts look at financial separation, what the factors are. So that might just help her in the meantime to understand how the courts apply the laws and what the considerations are. But really, she will be okay if there is the money there. It's just a matter of her knowing what her options are.
And for anyone on this call who doesn't know what your book is called, or anyone watching this after, so it's the...
As if I haven't shouted about it enough.
We'll shout about it more.
Here you go, one I prepared earlier. The Family Lawyer's Guide to Separation and Divorce by me, Laura Naser. It covers the separation part, so whether you're married or unmarried. I talk about child arrangements and how the courts approach child arrangements. And I also talk about financial separation. There's a bit in there about domestic abuse, and there's also a bit in there about the preemptive actions you can take. So cohabitation agreements, nuptial agreements, etc.
Amazing. Cool. A Bible for our community. So the next question is, where do you start? Married and separated, shared property, 2 kids, both work. I've had some free advice, but I feel completely overwhelmed, and it comes down to me to fund a divorce and settlement, which I am told could easily be 2 to 5 grand without court.
Yeah. It is overwhelming. It's so overwhelming, and it's very much the where do I start? And that's exactly why I wrote my book, actually, because people have this, oh God, it's so overwhelming. And if you Google things, you know, there's so much information, not all of it is relevant to you. You don't know whether or not it's relevant to you. It is really overwhelming. So I have a lot of sympathy. Reading my book would probably be a great starting place. I think then having a meeting with a lawyer, getting that initial free advice, the lawyers that offer that, it tends to be limited to 30 minutes. You know, by the time you've told them your name, your date of birth, your address, your spouse's or your partner's name, and whatever, you've gone into quite a lot of time already, and you've not really got much advice. I don't think they are as valuable to the clients as people perceive them to be. It sounds great, but I don't think you really get that detailed advice that is going to make you feel like, A, you know where you're going and what your next steps are, and B, have confidence of what your position is. So that's why, as I said, initial meetings with me tend to be a bit longer, an hour and a half, 2 hours, but it is bespoke. We get into the detail. You come out with it knowing this is your action plan, these are your options, and hopefully some confidence of knowing, so that when you go back home or when you next speak to your ex and you want to talk about things, you have more confidence of actually thinking, well, I know this is right because I've had a lawyer talk me through this, and I know that it's fair for me to say this, it's reasonable. That will help take the overwhelming feeling down. But funding it is difficult. If you don't have the money in your bank, you know, it is a necessary means to an end. You can do the divorce yourself online. I would be very cautious about doing your financial separation yourself without any legal advice. Same too with child arrangements, really. It's better to get some advice. You know, credit cards, taking a loan from a bank. There are litigation loans available. People can apply to specific lenders who will loan in, particularly an example, if you're doing a financial separation, where you know you're likely to get your money released at the end. They will loan you the money in that interim period. So it is something that will cost money, but it also means you know you're doing it properly, you've had advice. With finances and with children, really, it's very difficult to undo something. You have one shot of doing it properly. So go with the correct information, go with advice.
Yeah. Okay, great. I would love some advice on missed 18. So this person has missed £18,000 worth of CMS payments. He's refusing to work now and driving around in a Merc while I struggle. Can't go back to the courts. What with the divorce and custody, he's already cost me nearly 60 grand.
Okay. Well, the CMS isn't through the courts. You go back to the CMS, it doesn't cost you anything to go back to them and ask them to enforce it. Having actually said that, I don't think they may now charge, like, I think it's like £20 fees and things to do things. I can't remember what their fees are, but it won't cost you 60 grand. You go back through the CMS and ask them to pick it up. If you've got a CMS order and he's breached it and not varied it, then go to them, go through them and get them to look into it for you.
Okay, great. I am just conscious of time, and there are a couple more questions, but there's also one from somebody here on the call that I'm going to use. And if anyone else on the call would like to ask a question, maybe just pop a note in the comments and let us know. You can either type it anonymously in the comments, or if you message us or me directly, or you can let us know and say it on the call. So let us know now if you want to do that. Otherwise we'll do a couple more from the pre-asked questions. But so there's a question that's been asked in the messages here. Are prenups now recognised under UK law? Would ideally like to have one in place for any future marriage.
So nuptial agreements are not automatically binding in law, but we do now have set rules. And as long as you comply with those rules, such as You both do full and frank financial disclosure. You both get independent legal advice. You've signed it within a certain amount of time before the wedding. There's no duress. Then they are highly persuasive. Should you later divorce, and therefore one of you may then try and argue that you shouldn't be bound by it. If you enter into a prenuptial agreement or a postnuptial agreement, you can do them after a wedding. And at any point after a wedding, you could be married 20 years and then go into a postnup. You must, as long as you've done those rules, you've abided by those standards, then you should consider yourself to be bound by it. And they are highly persuasive now. We've had enough tested through the courts that as long as those guidelines are met, it is likely that it would be upheld.
I'm assuming, though, it's easier to convince somebody to do a prenup over a postnup.
Well, postnups tend to come into place, like say you've inherited. So during the marriage, you've unexpectedly inherited, or you've got a business and it's suddenly boomed. It's easier when you're nice with each other and you're happy to get people to agree to a nuptial agreement pre or post.
Yeah.
Because, you know, it's not kind of we're having an awful time, so we need to do this. It's something has changed in our circumstances that we didn't expect, so can we just make sure that this is dealt with?
Yeah. Okay, great.
And the same applies for unmarried couples. You can do cohabitation agreements. So don't just think the only way to protect yourself is if you then go on to marry. Cohabitation agreements apply for those who want to just cohabit and not marry.
Great. So this is something we'll have to cover in our session about what to do right the next time. How to set ourselves up for success, even if things don't go forward the way we plan. So the next pre-asked question, my decree nisi was granted on the 2nd of October and my solicitor asked how I want to proceed. The issue is that I instructed her to send my ex a letter to outline what we had agreed in mediation to be able to draw up a consent order with a clean break to finances, but he never got back to her. I also then got in touch with him this month to address where we were regarding the decree nisi and what we needed to do to not cause a delay, and that I was happy to discuss any issues he may have. He replied to say he couldn't remember what he agreed to and that he would dig out the letter and get someone to look over it.
Okay. So in that circumstance, I think it comes down to her solicitor and going back and saying, look, this is what he said. We need to move this forward. What can you do to help? So, you know, I can't advise on specific circumstances, but that's what I would suggest is it's just a matter of, it's not high priority. There's clearly some contention, but not massive contention because it's not something that they've come back on straight away. So it's probably more just a matter of giving them a bit of push along as opposed to there being a big problem there. So just utilize your solicitor.
Okie doke. So this is the last pre-asked question from the community. So if anyone on the call now wants to ask a question, do it now or forever hold your peace. Well, until our next Q&A anyway. So this one now, oh, you know what? This is actually a continuation of the last question, which you've answered. It was just a much longer question. So I think that's it. Yeah, I think that's it, Laura. So thank you so much again for, I feel like I learned so much about family law every time we speak. And I don't know how your brain can hold all of the different like specific things that come up and how it all works. But it's so helpful and valuable, obviously, for the Frolo community to get some proper guidance on all of this. So thank you.
Well, thanks for having me. It's always a pleasure. One thing I would say is the Frolo community is particularly in lockdown now. People are like getting their bubbles together, but you know, it's really tough. So the community, you know, I think it's brilliant that you all have each other and you've got somewhere to go and to talk about these things. So utilize the community where, you know, a virtual community is brilliant. It's so good. So many of my clients say how good it is for them. So well done to you.
That's so good to hear. Yeah, no, the virtual meetups will be ramped up now in the next few weeks, no doubt. But thank you so much, Laura. We would love to get you back soon. So we'll hopefully organise that and do another one of these as soon as possible.
Yeah, it'd be great. Thank you so
Thank
much.
you. Thanks everyone for joining, and good luck with lockdown part 2. Keep engaging on the app and on the feed and with virtual meetups and everything. We'll all get each other through.
Yeah. Well, good luck, and start thinking about Christmas arrangements if you haven't already.
Good shout. Yeah. Okay. Thanks so much. Take care, everyone. Have a lovely day. Bye.
Well, thank you.
Bye.